Okay, so we're back. Let's now move in to talk about the legal issues or legal considerations in relation to big data. So in the reading that you have, these really are the 5 big calls: competition and consumer law, privacy, human rights, and the rights of children. I mean, you could argue that rights of children are human rights, but there's a specific sort of dealing with the rights of children that I think are worth sort of identifying separately in that chapter. So let's start at the beginning. So competition ultimately is protected in digital markets in circumstances where large amount of data could provide market power to the owner. So competition laws are laws that effectively protect competition. It doesn't mean they protect competitors, they protect competition in a market. So the idea of competition laws and what are sometimes referred to as antitrust or anti-competition, anti-competitive behaviour laws is to ensure that those parties who have significant market power can't use that power inappropriately to lessen competition in the market. So large players can have a lot of data, right? And data can play a role in the various stages of merger control procedures, in understanding what it is that the combination of 2 entities and their data could bring about and how that could impact the market. So competition is a particularly interesting area, I think. The traditional regulatory framework for dealing with competition, Canatacci, Falce, and Policino argue anyway, that traditional regulatory framework isn't sufficient for the increasing number of what they refer to as triangular transactions that arise from the use of a platform. So a platform like a social media platform, Instagram, TikTok, Facebook, whatever your social media has a lot of information and then is able to match advertisers and potential purchasers in interesting ways. And so when we're looking at the combination of that use of data and the ways that the platforms can work together, we end up with unexpected competitive impact. The dominant platforms are all subject to special obligations because with market power comes special responsibilities to the intermediaries. And that is something that we started to explore last week and will be a continuing theme throughout this course. Next, consumer law. Consumer law and privacy protection, let's deal with them together. They aim to provide autonomous decision making by data subjects or by consumers, and effectively they're often mutually incoherent. So effectively the authors of the paper that you are reading argue that a tougher stance in checking the accuracy of information provided is required because the sheer massive data offers so many opportunities for people to cherry pick, to find and limit advantages to a smaller part of the population, but also to end up incorporating biases that limit availability to certain elements of the population. We began a little bit talking about human rights and the rights of children to an extent when we explored how these are impacted in Internet of Things, which is really looking at that question of consent for the tracking, tracing and using of data through connected devices when the person whose data is being collected wasn't the original purchaser or the person who gave consent, but maybe another household member, maybe a child, maybe a vulnerable person, maybe an elderly person. And that weighing up of the different benefits and the different legal concerns creates a range of different issues there that need to be considered, need to be thought about from a contractual element, but also from a human rights element. But this is all a little bit high level. Let's actually get ourselves a little bit more into the grain. So when we're thinking about data, and if we recognize that data is really valuable, then one of the legal issues that we have is, well, who owns the data and who owns the output of that big data analytics? Now, when it comes to intellectual property, one of the primary sources of intellectual property protection is copyright. So copyright is a statutory right. It's created by statute and it protects a wide range of materials, in particular literary works. So it provides the copyright owner with an exclusive right to exploit the literary work for a period of up to 70 years, depending on the type of protection and the type of material. So if somebody exercises those rights, if they disseminate the copyright material or they change it in some way or they copy it, essentially, if they aren't the copyright holder, they have breached the rights of the copyright holder. And as a consequence, they may have committed an offence. And at the very least, the copyright owner has, or copyright holder, will have legal rights to take action against the person who has breached their copyright. So copyright is a powerful, long-lasting bundle of rights, and it continues for 70 years after the death of the creator of that particular intellectual property. So, can we cover a database? And this is actually a really difficult question. And the short answer is yes. And the long answer, which you're about to hear, is you can, but there are a range of different things that you're going to need to think about. So despite the term literary work, copyright doesn't require any literary or creative merit. So copyright can protect a novel or a poem. It might protect some of the most beautiful artwork ever, but it also will protect a user manual or advertising copy or a tweet. It can extend to computer source code, to business correspondence, and a range of other documents. The key requirement for written materials is that they need to be original. So they need to be the product of a human author applying some creative spark, independent intellectual effort, or skill and judgment, and not just simply copied from another force. Okay, human element. Now, that's already asking us questions, isn't it? Or raising questions with us. Because the output of a big data analytic, the resulting product is not created by a human, it's created by compiling and performing calculations over a range of data. And so we need to actually ensure that we've got that human element there as well. So the other thing that's really important to understand about copyright is copyright protects the form of expression of ideas rather than the ideas or the information or the concepts themselves. The Copyright Act 1968 regulates copyright in Australia in relation to a range of different subject matter. And Section 10 of the Act includes in its definition of what a literary work is, tables or compilations expressed in words, figures, or symbols, and computer programs or compilations of computer programs. Section 10 of the Copyright Act also incorporates a definition. So a computer program is a set of statements or instructions to be used directly or indirectly in a computer in order to bring around a certain result. Okay, so in other words, a computer program can definitely be subject to copyright protection, but we still have a question mark over whether the data itself can be. So let me change slides here. So when we're thinking about whether a data set can be protected by copyright, it's going to largely depend on how the data has been arranged, structured, or presented. So we need that originality and we need that human intervention. The compilation of the data is what it is that is protected. So it's the compilation, the way it's organized, not the actual data itself. And this is because data itself often comprises factual information, statistics, contact details, sales figures, heart rate, altitude, traffic, testing results, and things like that. Copyright can protect the expression of the facts, but not the facts themselves. So in order to ensure that the data or the data set, the output of big data analytics can be protected, we need to look at a few things. So firstly, is it original? So businesses need, if they want to have copyright protection available to them, to ensure that they organize or arrange the data that they have in as original way as possible. For some types of data, I should say, there are only so many ways you can structure or group it. A really significant case in this area is the ICE TV and Nine Network case, where the court found that a schedule showing Channel 9 television programs and what time they were going to run it was just factual information. It wasn't a literary work. But the court might have came to a different view if the arrangement of that information was unusual. For example, it was ordered by genre or ratings or I don't know, whether or not President Obama watched that particular show. Anything original. So I think the courts, I've got some language from the court. In this case, a chronological arrangement of times at which programs will be broadcast is obvious and prosaic and plainly lacks the requisite originality. So, big data analytics, if the output is going to be subject to any level of protection, we need it to have some sort of novelty, some sort of originality in its approach. Also, we need to involve as much human input as possible. Relying too heavily on computers and automated processes when creating a data set can end up meaning that there's insufficient human authorship to attract copyright protection. The courts have used helpful analogies to clarify this position at both ends of the spectrum. Copyright will not subsist if a computer has been primarily responsible for the creation of the work. The language used in Telstra Corporation and phone directories was like a plane with its autopilot engaged, flying itself. But copyright can subsist if a human has operated the computer as a mere tool to create the data set like a novelist would use a word processor. Of course, disputes tend to arise in those grey areas in between. The full court held in the Yellow Pages case, so Telstra and phone directories, that copyright doesn't subsist in the Yellow Pages. That was the old pre-Google way of people finding phone numbers, because the compilation itself was largely automated by a software program with only really superficial human oversight. So, yes, data can be protected, but it needs to be arranged originally, and humans need to be involved in its preparation. This has big consequences for us as we think about AI. So what can businesses do in this case? They should be keeping an eye on who's involved in compiling the data, and they should be keeping detailed records of this just in case they ever need to defend a claim that is made against them that they don't have copyright. It's probably actually would be the other way around as I say that out loud. If somebody steals the data and starts to use it, and they want to claim that they have copyright protection and get the benefit of those exclusive rights to exploit that particular expression of the data, then they need to be able to keep the records and make sure that they've got them available to help them with their defence. So maintaining records of who created what and when will place organisations in a better position to establish who owns the copyright in a final product. Ownership is going to depend exactly on who created the data set and their contractual or other legal relationships with the organisation. So employees, as a general rule, work that is undertaken by employees will belong to the company or the person that employs them. The other thing to remember here is that copyright will only subsist in something like a data set if the efforts in creating the data set were directed towards creating some material form. Efforts directed towards antecedent or preparatory stages of the creation process are irrelevant to the question of whether a data set is protected by copyright. Even though you've spent millions and millions of dollars in developing marketing surveys, holding focus groups, reviewing consumer responses, and all of that sort of stuff, it doesn't necessarily mean that the resulting compilation of the feedback data will be protected by copyright, even if there's real commercial value in that feedback data. So since the 1990s, the European Union have been trying to overcome these commercial difficulties. And in Europe, there is a separate database right that sits alongside copyright. This database right doesn't completely avoid the types of obstacles that datasets under Australian copyright law face, and Australia has not yet had any real attempt to create a database right. And as far as I'm aware anyway, there are no current plans to introduce one. The government does produce information about its policies in relation to the digital age, intellectual property, etc., quite regularly. And of course, these are relatively easily found on the minister's pages or on the industry websites. So you might want to have a look there if this is something that you will see there'll be some continuous change for. So, copyright, yes, technically maybe, sort of, kind of, but not really. Let me talk about another type of protection that is probably more relevant to the output of big data analytics, and this is called trade secret protection. So trade secrets are protected under equity, and actually, well, I'll explain equity a little bit in a minute. I'm pretty sure I've got it on a slide, and if not, I'll be editing, so let's see what happens. So trade secret protections are about protecting the secrecy of information that is meant to be secret. And when we go back to the very beginnings of intellectual property and the creation of this statutory right to copyright, effectively your options are twofold. So there are statutory rights, actually I'm not going to call them that, there are bases under statute for obtaining exclusive rights to exploit intellectual property. The primary ones of these are copyright, which I've just discussed, and patents, where essentially in exchange for publishing your work, giving form to your idea, you get a statutory right to exclusively exploit that work for a limited period of time. The alternative to taking up that statutory right is to actually just keep it a big secret, to not share the information in any way. And so copyright and patents in particular, have been created to incentivize people who have good ideas to share those ideas. But you will notice that copyright doesn't protect the idea, it only protects the expression of the idea. So trade secret protection is really important. A secret that is not generally known or readily accessible to people within circles that normally deal with that kind of question has value because it's a secret and has been the subject of reasonable steps in the circumstances to keep it a secret will get the benefit of trade secret protections. So a range of different categories of information can be protected this way. They include private secrets, your information for the government, professional information, but also processes, formulas, customer lists, business secrets, ideas that you have for new campaigns or new inventions, and data, which is what's really important to us in this particular circumstance. So if somebody breaches your trade secret, in other words, it was a secret and you can establish that they have shared that secret when they didn't have permission or the right to, so they've either stolen the secret and shared it, or perhaps they were a former employee or a friend or a customer or somebody who was subject to a non-disclosure or trade secret agreement, then the equitable doctrine of breach of confidence would give you the ability to sue that person for breaching the secret and to take an action. So as I mentioned before, this arises in equity. Equity here is actually a reference to a particular body of rules. They evolved in a separate set of courts from the common law courts and really only apply where they sit alongside the common law, but they really only apply in circumstances where it would be unfair for statute or for the common law to apply. But it's not as simple as just generally unfair. There are a range of equitable processes that need to be addressed, and relying on an equity is a very difficult thing to do in practice. So the equitable doctrine of breach of confidence states that where a party, the confidant, the person who has heard the secret, acquires confidential information from another, the confider, a duty of confidence arises either under contract, as implied by their relationship, or the specific situation. So the confidant is not at liberty to communicate the information to a third party without the consent or if it's against the wishes of the confidor. So if there is a breach of that obligation, the plaintiff needs to establish at least one thing. They need to establish, firstly, that there is an obligation of confidence. It's one of the things that makes the equity so hard. And secondly, they need to show that the threatened use, either of those, would constitute a breach of the obligation. So 2 steps. You have to establish if there is an obligation and that the use or the intended use would result in a breach. So to do this, you need to be able to provide proof that the defendant or the person who has the confidant, sorry, I couldn't remember the word I had on the last slide, the confidant obtained the information from the plaintiff and that it has been or it will be used or disclosed in an unauthorised manner. So one of the defences to a claim that you have breached somebody's obligation, breached an obligation of confidence, is that you didn't get the information from the person who is making that claim, that you found it some other way. You compiled that data using a different system. Okay, so now let's talk about what defences are available if a claim has been made that there has been a breach of a trade secret. So remember, the plaintiff needed to demonstrate that there was an obligation of confidence in the first place and that that obligation is in fact breached or about to be breached in some particular way. So there are a couple of defences. So they won't be successful if the confidant is suffering some sort of injustice, if there was some reason why it was appropriate for them to release the information. These are case by case. Secondly, if it's a disclosure of a wrongdoing or for public safety of the community, this is usually the strongest approach. I was very interested to just see last week that there is a move at the moment for a range of different corporations to undo non-disclosure agreements that would prohibit employees disclosing that they have been harassed and in some cases sexually abused by their employers or by particular executives, and that a number of organizations have started to basically state that they will not enforce any non-disclosure agreements that they've entered into in relation to that. So yeah, often this is being used for those kind of reasons, and it's quite interesting to see how opinions change over time. And then thirdly, to balance the public interest. So again, is there a public interest that is protected by releasing this information or this particular secret? What happens when you are able to establish that there has been a breach? There are three different types of things that can happen: an injunction, an award of damages, or an account of profit. So because this is an equity, it's an equitable action, injunction is one of a number of equitable remedies that's available. An injunction is basically an order that prohibits somebody from doing something. And by the time your trade secret is released, it's usually too late. So often these actions are being brought when somebody is concerned that it will be released at some future time. And so these are really common orders here, because once the horse is bolted, it's too late and the damage is done. And there's usually very little in the way of financial loss up at the originating point. So it makes sense that an injunction is a really good remedy and often what is sought. Damages, on the other hand, so damages is a term we'll hear over and over again in this course, and damages is effectively what we call it when somebody is required to make a payment in order to make the injured party whole, to make good the damage that was caused by the wrong that they have been found to have committed. And thirdly, much more unusual and only available because this is an equitable remedy, again, is an account of profits. So if the use of the trade secret has resulted in somebody making money, then what we see is sometimes the availability of an order for that money amount to be paid back to the person whose trade secret it is that has been released. So that's all I want to talk about in the lectures. Don't forget that there are a number of explainers and videos on the platform this week, and there will be some fun to be had in the workshop, no doubt. I look forward to seeing you then, and then next week we'll start to get stuck into AI. I'm looking forward to that. Cheers.